We begin by examining evidentiary privileges. These are special rules of evidence that allow certain information, even if highly relevant, to be withheld from disclosure during legal proceedings. Privileges exist not to shield wrongdoing, but rather to protect vital societal interests by encouraging open and candid communication within specific, protected relationships. In the context of litigation, two doctrines dominate this area: the attorney-client privilege and the work-product doctrine. The attorney-client privilege focuses narrowly on protecting confidential communications made between a client and their attorney for the express purpose of seeking or rendering legal advice. In contrast, the work-product doctrine protects materials prepared by an attorney or their agents specifically in anticipation of litigation or for trial. While both doctrines are essential pillars supporting our adversarial legal system, they serve fundamentally different functions and are governed by distinct rules regarding scope and application. Understanding this initial distinction is key to mastering privilege analysis moving forward. Now we transition to the core requirements for the attorney-client privilege to attach. For any communication to be shielded, 4 essential elements must be satisfied. First, there must be an actual communication between the parties involved. Second, this communication must occur between privileged persons, meaning the client, the attorney, or their necessary agents assisting in the legal representation. Third, the communication must have been made in confidence, implying that no unnecessary third parties were present who could defeat the secrecy requirement. Fourth, and critically, the communication must be for the purpose of seeking, obtaining, or rendering legal advice. If these 4 elements are met, the privilege attaches. It is vital to remember that this privilege belongs exclusively to the client. The attorney acts as the holder of the privilege on the client's behalf, but the client controls its assertion or waiver, not the lawyer. Building on the fact that the client controls the privilege, we must now define who qualifies as a privileged attorney and client. An attorney includes outside counsel, but importantly, it also covers in-house corporate counsel when they are acting in a legal advisory capacity, not merely a business one. For the client side, the definition extends beyond just the top executives. Under the landmark Supreme Court decision in Upjohn v. United States, communications made by lower-level corporate employees to counsel during an internal investigation are protected, provided those employees are communicating to secure legal advice for the corporation. Now, we must address the most significant limitation: the crime-fraud exception. This exception completely destroys the privilege. If the client seeks legal advice from the attorney for the purpose of furthering, committing, or concealing an ongoing or future crime or fraud, the communication loses all protection. The privilege shields past wrongdoing, but never future malfeasance. We have thoroughly examined the attorney-client privilege, its scope, and its critical exception for crime and fraud. Now, we pivot to a distinct but related concept: the work-product doctrine. While the attorney-client privilege protects confidential communications, the work-product doctrine, codified in Federal Rule of Civil Procedure 26(b)(3), serves a broader purpose. It shields materials prepared by a lawyer or their agents in anticipation of litigation or for trial. This protection is focused on the lawyer's preparatory efforts, strategic thinking, and investigation, rather than solely on confidential client communications. A key difference is the trigger. Attorney-client privilege can apply anytime a client seeks legal advice, even in the absence of pending litigation. In contrast, the work-product doctrine only activates once litigation is reasonably anticipated. This anticipation marks the dividing line where the doctrine begins to shield the lawyer's work product from discovery. The work product doctrine recognizes 2 distinct categories of protected material: each receiving different levels of scrutiny upon discovery requests. The first is fact work product. This category encompasses the raw, objective materials gathered by the lawyer or their agents during preparation for trial. Examples include witness statements, physical evidence collected, internal documents generated solely for investigation, or preliminary drafts that merely compile facts. This represents the factual underpinning of the case preparation. The second, and significantly more protected category, is opinion work product. This is the core of the lawyer's strategic thinking. It includes the attorney's mental impressions, personal conclusions, legal theories, strategic assessments, and opinions regarding the case strategy. Opinion work product receives near absolute protection because exposing the lawyer's subjective strategy would fundamentally undermine the adversarial process. Understanding this division between objective facts and subjective analysis is crucial for applying the doctrine correctly. We just established the two categories: opinion work product and fact work product. The level of protection afforded to each differs dramatically. Opinion work product, representing the attorney's core mental impressions and legal theories, receives near absolute protection. It is almost never discoverable, period. The court strongly disfavors compelling disclosure of a lawyer's strategic thinking. Fact work product, however, is only conditionally protected. While it is shielded from routine discovery, this protection can be overcome. To pierce the protection surrounding fact work product, the party seeking discovery must satisfy a rigorous two-part test. First, they must demonstrate a substantial need for the materials. Second, and critically, they must show that they cannot obtain the substantial equivalent of that information without undue hardship. If both substantial need and undue hardship are proven, the court may order disclosure of the underlying facts, but usually not the attorney's opinions. Now that we understand how the work product doctrine protection can sometimes be pierced, let us shift our focus back to the attorney-client privilege and examine how this fundamental protection can be lost entirely through waiver. The most common way the attorney-client privilege is waived is through voluntary disclosure. If the client voluntarily discloses the confidential communication to any third party who is not covered by the privilege, the protection is generally destroyed for that communication. A second, more nuanced form of waiver arises when the client affirmatively places the legal advice at issue during litigation. This is known as subject matter waiver. For example, if a client claims they relied reasonably on their lawyer's advice as a defense, they have waived the privilege over all communications relating to that subject matter. Finally, we must address inadvertent disclosure. Federal Rule of Evidence 502 provides relief here. If privileged material is disclosed unintentionally, the privilege is not automatically waived, provided the holder takes prompt remedial action, such as requesting the return of the documents. This rule also allows for clawback agreements between parties to manage inadvertent production without waiving privilege over related material. We just covered how the attorney-client privilege can be waived. Now, let us examine the waiver rules specific to the work product doctrine. The standard for waiving work product protection is slightly different and often hinges on the effect of the disclosure. Waiver occurs if the voluntary disclosure substantially increases the opportunity for an adversary to obtain the protected information. Think about how this differs from the attorney-client privilege. Crucially, the work product doctrine offers stronger protection for the attorney's mental processes. If you disclose underlying facts gathered for litigation, like witness statements, this disclosure does not automatically waive protection for the attorney's opinion work product, meaning their mental impressions or legal theories. This distinction is vital. While disclosing facts might waive protection for those specific facts if they are not otherwise protected, The core mental impressions remain shielded unless the disclosure clearly demonstrates in abandonment of the litigation strategy itself. The focus here is less on the communication itself, and more on the strategic impact of revealing preparation materials. We have now thoroughly examined both the attorney-client privilege and the work product doctrine, including their respective waiver rules. For success on the bar exam, you must internalize these core distinctions. Remember this fundamental split. Attorney-client privilege shields past confidential communications made for the purpose of obtaining legal advice. In contrast, the work product doctrine protects materials prepared specifically in anticipation of litigation or for trial. Ownership is another key differentiator. The attorney-client privilege belongs solely to the client. The work product doctrine, however, primarily shields the lawyer's thought process and preparation efforts. To approach any privilege question quickly on the exam, use this three-step synthesis checklist. First, ask, was this a confidential communication seeking advice? If yes, consider attorney-client privilege. Second, ask, was the material prepared in anticipation of litigation? If yes, consider the work product doctrine. Third, and critically for both, has the protection been waived? Mastering this framework ensures you correctly identify the applicable rule and its scope. These doctrines are cornerstones of effective legal advocacy, and understanding them deeply is essential.